my delegates, thank you very much for inviting us to this beautiful, beautiful event and this beautiful country, Ghana. I'm also very talkative and passionate like Fidoz. So the biggest thing to do is just to structure me into one area and give me notes. Otherwise, I can go on forever. So I'm trying to get to the time. So today we meet to discuss dispute resolution, especially regarding tax tribunals. But before we can speak about tribunals, ombuds, and reform agendas and their role in the ecosystem, we begin the principle in very deeper than that structure, that when fairness or disputes increase, compliance erodes and distrust grows. So when we look at that, the impact of fairness into this whole ecosystem, that if we have a proper tax ecosystem with proper dispute resolution processes or mechanisms, we want to increase in dispute. There's going to be a lack, often leads to more conflicts, disagreements, and parties are involved. So fairness is missing, disputes increases, compliance erodes, and distrust grows. But when fairness is present, we get cooperation, you get compliance, and you get that investor confidence rise. And the tax base grows in your country. So when we speak about, that's why dispute resolution is not just procedural, it's about governance, fairness, and legitimacy. So today I will want to explore interconnected pillars. Just want to get there. Okay. Today I want to explore the interconnected pillars. And the pillars that I want to look at is tax tribunals, the role in the challenges, ombuds institutions, the purpose and emerging use in Africa. And I also want to speak about the protection and enforcement of taxpayer rights. And to ground this in practice, I will share case studies from South Africa of what we've done in the tax ombud. This is not a perfect model, but it will demonstrate how fairness can become actionable, institutional, and measurable. But before we can turn to Africa, let's just understand first what's going on around internationally with regards to tax appeal tribunals' roles and challenges. Now, I want to talk about around the world. The most trusted system combines 3 layers of accountability. And the first one is independent tax tribunals. In countries like United Kingdom, Canada, and Australia, they have independent revenue authorities staffed with tax-literate decision makers. And, well, they are tribunals, independent revenue authorities staffed with tax-literate decision makers required to publish. They're required to publish consistent jurisprudence. Tribunals answer the legal question in terms of, was the law applied correctly? But independent institutions like the tax ombud answer the first question, was the taxpayer treated fairly? And that is seen around the world with institutions in Canada, in Australia, in United Kingdom, where they have both tribunals and the tax ombud. Now, what we have international standards that are there, and most of you know about it, is the mutual agreement procedures, the MAP, which is built into tax treaties and allows the tax administrators to resolve cases where taxpayer has been taxed twice on the same income. Well, it protects multinational businesses, investors, cross-border workers, and African companies expanding into international market. But MAP matters because prevents double taxation and economic harm, allows disputes to be resolved between governments, not in courts, and it reduces litigations and time for taxpayers. Now, MAP is not only as strong, it's only as strong as the domestic system behind it. So a country with slow, unresponsive, and unclear dispute processes will automatically have slow, ineffective MAP outcomes. Now, with the base erosion, profit shifting, Action 14, you find that the international commitment to timely, transparent, effective dispute resolution. Now, Action 14 requires participating countries to resolve cases in average of 24 months, publish clear dispute resolution processes, allow taxpayers to map even while domestic remedies are ongoing, commit to binding arbitrations where necessary. In other words, BEPS turns fairness into something measurable and enforceable, but not inspirational. Now, when we look at these international bench mechanisms that are there, if taxpayers cannot resolve dispute fairly at home, no treaty or international standard can restore trust. With that benchmark in mind, I had a look at other countries in our continent on Africa to understand the core continental implications of this when it comes to disputes. If African tax systems wish to attract investment, avoid double taxation conflicts, and align with international standards, then domestic dispute mechanisms must be treated independent and efficient. Examples or mechanisms that are there internationally, BEPS, do not replace tribunals and ombuds. They depend on them. A weak domestic dispute leads to delayed MAP cases, investor uncertainty, treaty partner pressure, global tax governance ratings, poor global tax governance ratings. And this is very important for us if we want a strong position in Africa as a fair, predictable, investor-ready tax environment. Now, we know how all the tribunals around the country, even the world, and their roles and challenges that they face. Now, they exist, tax tribunals exist to provide taxpayers with an independent but also specialized accessible forum to challenge decisions of the revenue collector or a revenue authority without cost and formality of full litigation. So across Africa, we do know that the appeal structures are there, but their effectiveness really vary for all of us. So where we see that in Ghana, there is a tax appeals board. In Kenya, there's a tax appeals tribunal, the TET. In South Africa, we have a tax board, which deals with smaller matters, and a tax court, which deals with more complex matters. But in Uganda, Zambia, Botswana, Namibia, they also have a similar type of statutory appeal. Now, the strengths of a tax tribunal on the continent is that the legal structures exist in many jurisdictions. Taxpayers have recourse outside revenue authority, and some tribunals use virtual hearings, which, of course, were introduced post-COVID. Kenya and South Africa have published selected decisions, which for improving transparencies. Challenges across tribunals we all are familiar with. And I think all of us understand that independence concerns. Some people feel that many, are funded by the Ministry of Finance, of course, or administered by the Revenue Authority, so the decision will flow towards the Revenue Authority. Some lack published decisions. This is very important because it limits jurisprudence and predictability and academic and legal review. So if we have, and this prevents a transparent system. Now, we all know case backlogs and delays. You hear of institutions that have been running, for cases that have been running for months, caused by insufficient staffing, limited budget, and manual systems. Restricted access also, meaning that the internal objective or objection processes must be exhausted first and delaying justice. Now there's also capacity gaps where these panel members are not always trained in tax law because tax is also a specialized area and not very attractive for most people in schools. There's also cost barriers. The SMEs and individual taxpayers struggle to afford tax representation by tax experts. There's also low awareness. Many taxpayers do not know that tribunals exist or there's any mechanism that can help them when they have a challenge. Now, the key implications of this is that a tribunal created in law is not the same as a tribunal that delivers justice in practice. For tribunals to build trust, they must be able to be independent, transparent, digitally enabled, timely, and accessible to all taxpayers. That is the only one part of in the fairness equation. And the next institution deals not with legal representation, but with administrative fairness itself. And that's the Ombud institutions. So in Africa, internationally actually, we've seen that there are ombuds in Canada, in Australia. Interestingly enough, in Australia, not only do they have an ombud, they have also an inspector general, which deals with governance within the revenue collector. And also the UK, they all monitor fairness rather than a legal compliance of tax matters. Because really, truly speaking, before something can be complex, really starts with service. So Tax Ombud protects taxpayers from unfair treatment and procedural abuse, delays, poor communication, and administrative errors by the revenue collector. It does not overturn assessments or technical matters. That is the role of the tribunals. The tribunals look at the technical matters. It answers the different question. Was the taxpayer treated fairly? So when we look at African countries, we currently do not have a lot of tax ombuds around Africa. South Africa just started in 2013 with the South African Tax Ombud, that's where I'm from, and Tanzania started in 2023 with the regulations, they introduced their regulations, and Nigeria just passed their legislation this year to create a tax ombud that's gonna start in next year in 2026. Other African countries rely on general public protectors, not tax-specific oversight bodies, to understand how ombud works in practice. I will be speaking about the South African tax ombud. Now, in South Africa, the tax ombud is it's independent and impartial mechanism for resolving administrative complaints against the revenue collector. Well, the mandate we look at to resolve complaints that are service failure and delay, error, and procedural unfairness. The second part of our mandate is to look at systemic issues. Systemic issues are issues that actually affect a larger population of the tax base. For example, if we find that there is, and we'll be looking at some of them, there's delay in refunds, in delay in the revenue collector. Pays refunds, we look into that. Not only looking at one complaint, but we will look at the whole system, what causes the delay. So we recommend corrective action to the regulator. And I have to say, since we've started with the tax ombud, the revenue collector in South Africa, SARS, has been very, very compliant, and they have actually taken 98% of our recommendation, 98, 99 in other years of our recommendations, and they have implemented them. What the tax ombud may not do, but is to review tax legislation and tax policy, review revenue collector policies unless it relates to procedural fairness, review matters under objection or appeal unless the complaint concerns administration of the objection, and review decisions on matters before the tax court or tribunal, or issue binding rulings. So the recommendations that we send out are not binding. Despite these limits, the tax ombud prevents disputes, reduces litigation and pressures, and restores taxpayer trust, especially through these systemic investigations that I'll be telling you more about. Okay. So the first case study that I want to look at is the systemic investigation on VAT refund delay investigation. So we did a VAT refund delay investigation in 2020. So thousands of businesses were coming to us, especially small, medium business, and they have experienced a revenue collector withholding refunds and delaying them, sometimes for months, in other instances they were for years. What a delay in refund does, don't just slow businesses, but they also kill it. And we've seen in some of our case studies that some businesses went down, because for small businesses, cash flow is survival, it's not a convenience. So findings that we found is that refunds withheld without lawful reason. So we looked at all the data and we found out that refunds were withheld without reason, and that there was no escalation method or oversight mechanism. So if you're waiting for your refund, you just wait, and that's it. There's nothing that you can do as a taxpayer. And some taxpayers were left without no explanation. So you'd find that these things are the kind of things in a big business that allows them to approach the tax board or the tax court because they have the funds to do so. But for small, medium enterprises, these are the disputes that they cannot take anywhere. So as the tax ombud, we took this upon ourselves to do this investigation. And we made recommendations to the Revenue Authority, and within no time, I think it took about 2 years for them to do our recommendations, to insert our recommendations. These complaints moved from being the #1 complaint in our books to being almost #5. So delays in refunds were really, really reduced. So these reduced a lot of complaints. So you'd find people saying, our revenue collector in South Africa is efficient, I got my refund on time. It's because of these recommendations that we put through. So our revenue collector, to fix the delay in refund, is not a service improvement, but it was for us an economic rescue for small business enterprises and for small business enterprises. And this for us was very important. the next case that we had a look at that probably was very important. Did I miss it? There, okay. It was about disputes. The gremlins are working against me. Okay. The next case that is delays in dispute resolution. Now, taxpayers lodge objections because that leads, as I said, to you going to the tax court or the tax board. Some of it's a requirement in some instances. When you've lodged your objection, but you receive no update, or you just hear silence. This was one of the things that we looked at, because these are the disputes that would lead to you going to the tax boards or the tax courts or the tribunals. So we found that when we looked into the matter after complaints by taxpayers, is that there was no tracking system for disputes for stages. For example, you would lodge your objection, you get your acknowledgement, and you don't know what happens thereafter. So is it assigned to someone? Is someone looking into it? When should you expect the results thereof? Because the revenue collector, according to the tax administration, must finalize your objection within a certain time, 60 days after receiving your objection. And if there's more additional information, 45 days to finalize it. But in this case, you would find nothing happens. So when we speak about no tracking system, so you get no case number, you don't know who's got it, who's working on it. So this was something for us that was very important, because dispute delays or tax dispute delays was something that you would find that for months, for years, that big or small medium enterprises or even individuals will be waiting for their case to be finalized no recourse or not knowing where to go. Another thing that we saw was that there was an escalation to courts or to tribunals caused by administration neglect. By an administration neglect, I mean there were tribunals that, so these cases will be given to tribunals for legal, not only for legal disagreements, so nothing legal. It would be just silence by the revenue collector or delay, or in this case, maybe a failure of basic administrative follow-through, so nothing technical. So we had a look at the data that was available. What is great about the South African Tax Authority is that all their information with regards to objections is digitalized, especially when you speak to your auditor. So we could see how long has the case been on the system without it being looked at. So we had to actually go through all the data to see how long on average does a case take the revenue collector, and we found out that some lay there for years without being even assigned. Some were just asking constantly for the same information over and over again without the information being acknowledged, and the taxpayers would always be calling and requesting for progress, and nothing would be happening from there. After we had careful consideration, we had recommendations done to the revenue collector. And I can say this was one of those systemic investigations that had a lot of recommendations sent to the revenue collector, more than 20, and they managed to halve most of the recommendation by implementing our recommendations. And now this also moved from being one of our top systemic or top complaint to one that's not really a top complaint. There is a lot that has to be done in terms of monitoring time. So inventory backlogs, communication with the taxpayer that hasn't been done as yet, but it's something that reduces also tax disputes. When we had to look at what is the recourse in all of this, why is the revenue collector unable to meet its requirements? Because these requirements in most of our countries, especially around Africa, they are listed in the service charter, or what most countries call the service charter. It tells you how long a case is supposed to take you, what are the commitments that the revenue collector is making in terms of giving you the service, and how enforceable is this. But we found out that it's a list of service promises that were not enforceable. And we came up to say, let's look at the service charter and see how best we can enforce them. And the best way to enforce them that we thought would be to introduce rights, Bill of Rights. Well, the rights existed. They were there. It's not something that we came up with, but they were scattered across various tax acts, regulations, and case laws. So the Ombud created a booklet of what you called a compendium of rights and taxpayer rights, entitlement, and obligations. And when you look at what other countries are doing around the world, especially tax ombuds, they would have what they call a Bill of Rights. And in this Bill of Rights, they will list what rights taxpayers must know about when dealing with the revenue collectors. But in South Africa and many African countries or countries around the world, taxpayers only depend on the service charter done by the revenue collector, but it's not enforceable. So one of the key things that we looked in compiling, we saw that in introducing the compendium on rights, obligations, and entitlement, that when we start telling taxpayers about simple rights like the right to finality, that your case cannot be there for years and years to end. You have a right to finality. You have a right to fair and impartial treatment. You have a right to privacy and confidentiality. You have a right to information and explanation. And you have a right to dispute or appeal decisions. You have a right to timely service, and you have a right to complain without fear of victimization. And these rights, when we introduced them to taxpayers, it actually assisted us with how they interact with the revenue collector. You'd find that most of the conversations that the revenue collectors would speak to us about would be how the taxpayer would come and say, but the tax ombud says, I have a right to complain to you without fear of victimization, or I have a right to know what's happening to my case because I deserve a fair and impartial treatment. So across Africa, most countries operate with service charters and not actually mix it up with the Bill of Rights, because the next step is clear. Africa must move from service promises to enforceable taxpayer rights. So to know when to get to a dispute takes, it's great, but you must also know that where to go when the revenue collector does not meet that obligation or that service. So to build taxpayer trust and strengthen compliance, voluntary compliance, African governments should prioritize independent and well-structured tribunals. And I'm speaking about tax-specific ombuds, independent, well-structured tax tribunal with published decisions. So if you establish a tribunal, it's great to publish decisions so that you enhance fairness and transparency in dispute resolution. when we speak about how to have better tax disputes processes, tax-specific ombud institutions, not public protectors, should be in all jurisdictions. Digital case management and transparency, we spoke at length, I heard at length, it's spoken here with regards to digital transparency. As I said, this also assists us in our systemic cases on dispute resolution. A digital case management and transparency system is important for voluntary compliance. Legislated taxpayer rights framework, if you know the service that you are entitled to, you should also know the rights of what happens when those services are not met. Capacity development in tribunal members, ombud staff, and tax officials for us is very important, and also regional alignment through maybe, I would say, ATAF or AU-led African Tax Fairness Dispute Resolution Standards, some kind of standards so that we can be able to see how best to benchmark ourselves around the continent. What we should be discussing this afternoon, especially in our plenary, is guaranteeing independence. So how do we guarantee independence of tribunals and ombud offices all across Africa? We also should be speaking about service charters and rights, and what practical steps can move African countries from not only service charter, but also to rights charter. How can a technology, like we've heard today, online tracking cases, virtual meetings, support fairness and reduce delays? And we heard from Fidos, there is a lot that can be done to reduce disputes. Should Africa adopt continent-wide standard or peer review models of dispute under ATAF or AU? And how do we prevent disputes? Not only resolve them through systemic monitoring and administrative fairness. So, in closing, a fair tax system is not sustained by penalties or power, but is sustained by trust. When taxpayers believe system is fair, they comply because they choose to. When they believe the system is unfair, they resist, they disengage, and they try to avoid. The work of tribunals and ombud institutions and taxpayer rights frameworks does more than resolve disputes. They strengthen our democracies, they protect human dignity and build investor confidence and makes the social contract deal real. So it's the importance of fairness, the effectiveness of our dispute resolution depends on it, and learning from our experiences, all of us, because in Africa, unlike we have an advantage to leapfrog when it comes to some of these procedures and mechanisms. So in closing, we would like to just say in the tax ombud system, we believe that tax systems do not earn legitimacy through power, they earn it through fairness. So thank you.